Hello, my name is David Thompson and welcome to Unit 3, Legal Studies. In Unit 1, when you began studying this subject, you spent some time learning where our laws come from. Let's take a few moments to refresh our memories on that topic by having a look at a short video.
It's an 800-year-old document, written on dried animal skin, in England, on the other side of the world, in a language we no longer use, that most people couldn't read even back then. So why is Magna Carta important to us in Australia today? Because it was the starting point for some of our most important human rights, things it's easy to take for granted. For instance, before Magna Carta, life was pretty cruisy. If you were a king, you could get away with all kinds of things. Forming your own armies, invading other countries whenever you fancied, and taxing people to pay for wars without even asking. Now, there were laws in those days, but some rulers believed they had absolute power and simply ignored them. That changed in 1215, when a group of landowning barons finally had enough of King John's behaviour. They decided the king governed by their consent, not just because he was king. So they got together and forced the king to agree to limit his powers by signing Magna Carta. It was the beginning of fairer rights for the people. The king also agreed he couldn't just add new taxes. Free men had to be represented by a common council to be taxed, which started the evolution of democracy. It also meant the king was no longer top dog, because above him now was the law. Or at least that was the idea. Kings and queens had a lot of trouble getting used to not being in charge. But over the next few hundred years, people power, in the form of Parliament, grew to be much stronger. In its Bill of Rights of 1689, the English Parliament formally decided it was the job of government to represent the people and protect their rights. These ideas came to Australia in English law. We know today if someone is accused of a crime, they have the right to a fair trial, and they must be proven guilty before they can be punished. Before Magna Carta, justice wasn't always applied fairly. Remember old King John? He was pretty good at filling up the prisons. But under Magna Carta, it was no longer up to him to decide whether someone had done wrong. It said, "No free man shall be seized or imprisoned, except by the lawful judgment of his equals or by the law of the land." Now you had to have a reason to lock someone up, and later people decided you also had a right to argue your case in front of a court. But in 1215, no free man didn't mean everyone, because in those days most people weren't free. They were poor peasants who served the lords. It took till the 16, 17 and 1800s before all men were free in Western countries, and most women waited until the 20th century. In 1948, after the atrocities of World War II, the nations of the world created the Universal Declaration of Human Rights. For the first time, the whole world recognised that everyone, it didn't matter who you were, had the right to enjoy freedom of speech, freedom of religion, and freedom from fear and want. It has been described as the International Magna Carta for all mankind. So, this faded old piece of animal skin has played a big part in shaping the democratic society we have in Australia today. But many people around the world are still denied their rights and freedoms. This reminds us human rights shouldn't be taken for granted, and until they are, the long story of human rights and freedoms that began with Magna Carta will continue.
I hope you found that both informative and entertaining. I'm very pleased that you've chosen VCE Legal Studies as part of your Year 12 course, but let me dispel a myth. Many secondary students believe that legal studies is only for those planning to study law at university. And that's very far from true. Many decades ago, Australian-born Judge Lord Atkin, about whom you've already probably heard quite a bit, told students in Birmingham that law should be taught as a Year 12 subject, and these are his words: because a knowledge of the law and its administration should be part of the ordinary equipment of the good and efficient citizen. He'd be very pleased that the Victorian curriculum includes legal studies and civics and citizenship, which has a substantial law component, and he'd be very pleased that we are all here today. What I'm going to do now is outline some of the ways in which you can prepare yourselves to do really well in legal studies. You might well ask the question, what should I be doing now? Now, the first thing that I'm going to suggest is that you get a hold of a copy of the study design if you don't already have one. The study design is the Bible for legal studies. In other words, what it tells you is exactly what the course contains, and perhaps even more importantly, exactly what it is you can be assessed on throughout the year and at the end of the year. So get a hold of a copy of it. You don't have to buy the expensive printed version. You can download it. You can download it from the Victorian Curriculum and Assessment Authority website. Print it out, stick it in the front of your folder, and from time to time, look at it and make sure that you're covering everything that you really need to be covering. Last year, you spent quite some time assessing how the operation of the legal system can be assessed according to those three criteria which cropped up time after time after time. And those three criteria, of course, were fairness, equality, and access. You'll continue to do that throughout each area of study in units 3 and 4 legal studies. So make sure you refresh your memories as to what those terms mean. The other thing that I think you should have in your folders is a copy of the Constitution. Obtain a copy of it. You can download it, or you can go to a bookshop and buy a copy. A downloaded copy is equally as good, but don't get a fright when you have a look at it. You're not expected to know what the whole of the Constitution contains. But during the course of this coming year, you are going to have a look at a number of segments of it. You'll understand those segments a great deal more if you see them in the context of the whole document. So it's a very good idea to have a copy of the Constitution to which you can make reference. It's also very important that you make topic notes. As you're working your way through the course, make notes as you go. Don't wait till the end of the year, because towards the end of the year, you should be making a knowledge audit like this one that's on the screen now. Then you can tick off, yes, I've got notes on each of these things. If you have to tick that you've got no on quite a few of them, then you haven't made your topic notes early enough. Start them from day one. They'll be invaluable when you begin to revise for the exam at the end of the year. Case notes. When you're recording cases in Unit 3 and 4 legal studies, make sure you record the facts. This is my old friend FIDS. F stands for facts. As you know, what's the case about? Who did what to whom? Secondly, what are the issues that the court had to decide on? What was the decision of the court? And what's the significance of that particular case? In other words, why on earth are we studying this particular case? Why is it important to the course? You wouldn't be looking at it if it weren't important in some way. It might be important because it's a very good example of the particular topic you're studying in Unit 3 or 4. It might be significant because it's changed the law, either added something to the existing law or taking something away. It also might be significant because you can use it as an example in the exam at the end of the year, perhaps in a number of different areas. There's no rule that says you can't use the same example if it's relevant in your responses. Now, can I make a suggestion that you don't throw out any of your Units 1 and 2 notes? You may find that the cases you looked at in Units 1 and 2 will be useful in units 3 and 4. So if you haven't had a big bonfire of your notes, pardon me, make sure that you hang on to them. You may find them useful in this coming year. Be guided by your teacher so that you get the ones which match this year's curriculum. There were some bits dropped out of last year's examination, last year's study because of COVID. Now those bits have all been put back. So make sure that you are looking at past papers that are going to be relevant to your preparation for this year's exam at the end of the year. So what does Unit 3 contain? Let's have a look. The Victorian criminal justice system. The distinction between summary and indictable offences. You may already have looked at that. You're going to have a look at the burden of proof. But if we're talking about the criminal justice system, the burden of proof rests with the prosecution. That is either the barrister appearing for the prosecution or the police officer in the magistrate's court. They have the responsibility of bearing the burden of proof. They have to prove that the accused person is guilty. You'll also have a look at the presumption of innocence. The fact that a person is presumed to be innocent until they are proven guilty beyond reasonable doubt. You'll also spend some time having a look at the rights of accused persons and victims of crime. And that latter point is one which has had quite a bit of coverage in the media over recent times. The rights of victims are something we're paying a lot more attention to today than perhaps we did in the past. Now, some of those elements you might well tell me we looked at in units 1 and 2, but you're going to be taking a deeper look at them and advancing them and developing them in unit 3. So please don't make the assumption that you know all of that already. As I said before, don't throw out your units 1 and 2 notes. They will almost certainly come in handy, particularly in terms of cases you've looked at, examples that you've used. You might find them very, very handy to have there at your fingertips. The second aspect of Unit 3 covers, or the second area of study in Unit 3 covers the Victorian civil justice system. Now here you're going to be looking at some other organisations. You'll be having a look at Consumer Affairs Victoria. What does Consumer Affairs Victoria do for the consumer? You'll be having a look at the Victorian Civil and Administrative Tribunal, which is an umbrella tribunal. You've probably already had a bit of a look at it. It's an umbrella tribunal that has a number of lists under that umbrella: small claims, anti-discrimination, and so on. Very important, contributes enormously to the resolution of disputes in Victoria. In terms of civil trials, you'll have a look at pre-trial processes. What do each of the parties have to do and submit to the court before a matter comes before that court for hearing? And in many cases, the pre-trial procedures have an end result which prevents the matter from going to court because they get resolved without the necessity of a trial. One of the things you're going to have a look at is the court hierarchy in resolving civil disputes. And this changes from time to time. Obviously, minor matters are dealt with in the courts that are lower in the hierarchy, and more serious matters get dealt with in courts that are higher in the hierarchy. And you'll learn about cases that go to each of those courts and why they go to each of those courts. Another important element that you'll look at in the civil justice system is court management. Courts are responsible in the civil justice system for the management of cases. Courts will issue instructions to parties. Courts may even insist that the parties go to mediation. Now, these are important elements. Case management by courts, very, very important in ensuring that those elements of justice that we talked about at the beginning are in fact met. Fairness, equality, and access. In this area, you'll also have a look at mediation, conciliation, and arbitration. Now, these are what we call alternative forms of dispute resolution, or sometimes appropriate forms of dispute resolution. And they're very important in resolving disputes. And that's what we aim for always with the civil justice system, resolving disputes so that people can get on with their lives as they would wish. And we'll also have a look at remedies. If a matter does go to court, what sorts of remedies can the court order? And you'll learn about injunctions, which are orders given by the court for people to do things or not do things. There may be monetary damages. Money may have to be paid over as a form of reparation for things that have been done. So remedies are an important element. Those are just two of them. And the third thing that I want to comment on is assessment. At the very end of the year, you're going to have to sit an exam. But there is assessment in Unit 3 as well. And this is school-based assessments. And in this area, you're going to be asked by your teachers to undertake one or more of the following. A case study. You may be asked to examine a particular case and write or deliver orally a report on that case. You may be asked to respond to a series of structured questions. You may be required to write an essay. You may be required to write a report, that is a report in a written format, write a report. Or, for those of you who are a bit tech savvier than I am, you might be asked to present a report in a multimedia format. And you'll know much more about that sort of thing than I do. Or you might be asked to write a folio of exercises, present a folio of exercises that you've completed during the course of Unit 3. Could be any one or combination of those forms of assessment at your school. Now, I hope you've had fun in Units 1 and 2, and I really hope that you enjoy Unit 3 and hopefully Unit 4 legal studies as well. All the very best.